Yes.
Thank you, my lord. So we're in Lloyd and Google, and I think I was up to paragraph 72. Over the page 613 in the authorities bundle, Lord Legate addresses the court's discretion at 75. Perhaps I could ask the lordships to read that.
75.
Paragraph 75 on page 613.
Okay. Yeah. Yeah.
And then he addresses 4 further matters from paragraph 76. The first one in respect of consent. I don't think I need to take your lordships to that paragraph. Then 78 over the page on 614, class definition. It says, while it is plainly desirable that the class of persons represented should be clearly defined, the adequacy of the definition is a matter which goes to the court's discretion in deciding whether it's just and convenient to allow the claim to be continued on a representative basis, rather than being a precondition for the application of the rule. Emerald Supplies illustrates a general principle that membership of the class should not depend upon the outcome of the litigation. Beyond that, whether or to what extent the practical difficulties in identifying the members of the class are material must depend on the nature and object of the proceedings. And then in 79 he refers to the position in relation to costs, which I don't think need concern the court on this occasion. And then paragraphs 80 to 82 he deals with position in relation to a claim for damages. And perhaps I could ask your lordships to read 80 and 81.
I think you asked us to read that before the adjournment.
I'm grateful, my lord.
Certainly I have read it.
I'm grateful, and my Lord Justice Nugee picked up on the point which is in 81, for 5th line down. It says, leaving any issues which require individual determination, whether they relate to liability or the amount of damages to be dealt with at a subsequent stage of the proceedings. And my Lord Justice Nugee was making the point that ties what Lord Legate said in 72 in respect of common issues to questions of liability as well as questions of quantum. And then, obviously, I don't need to take your lordships through the detail of the analysis on the data protection issues, but I just want to show you very briefly, if I can, the way in which, or a couple of short passages illustrating the way in which Lord Legate approached the matter. So could I ask you to go on to page 633, paragraph 147. This is obviously deep in the relevant reasoning, but if I could ask you just to look at next to the letter G, paragraph 147. The fundamental problem is that if no individual circumstances are taken into account, the facts alleged are insufficient to establish that any individual member of the represented class is entitled to damages. And then 148. The facts alleged against Google generically cannot establish that any given individual is entitled to compensation. To establish any such individual entitlement, it must be shown at least that there was unlawful processing by Google of personal data of which that particular individual was the subject. In considering whether the facts alleged, if proved, are capable of establishing an entitlement to damages, it is therefore necessary to identify what unlawful processing by Google of personal data is alleged to have occurred in Mr. Lloyd's own case, and also in the case of each other member of the represented class. What facts is the claimant proposing to prove to show that Google acted unlawfully in each case? The answer on analysis is only those facts which are necessary to show the individual falls within the definition of the claimant class. The premise of the claim is that Mr. Lloyd and each person whom he represents is entitled to damages simply on proof they are members of the class without the need to prove any further facts to show that Google wrongfully collected and used their personal data. Any such further facts would inevitably vary from one individual member of the class to another and would require individual proof. And then right at the foot of that page in 152, but the question must be asked is whether membership of the represented class is sufficient by itself to entitle an individual to compensation without proof of any further facts particular to that individual. And I'll come to my submissions on this point in due course, but I draw your Lordship's attention to those particular passages as demonstrating that the analytical exercise in which Lord Legate was engaged was one by which he examined whether the facts that had been pleaded by the representative were necessarily sufficient to establish the claim on behalf of each and every member of the class. And his conclusion in the end in that particular case was the answer was no. So that's all I wanted to say specifically about Lloyd and Google. There's a subsequent first instance decision, as your Lordships may have seen, by Mrs. Justice Williams in the case of Prismal and Google. I'm not sure I've got I was going to take your Lordships through some of that. I'm not sure I've now got time. It's you've got the relevant passages. I hope I identified. If not, I can provide you with those. It's an illustration of a case where the judge undertook the kind of analysis that Lord Legate undertook in Lloyd and Google, which was to examine whether, in that case, liability could be made out on behalf of every member of the class by reference to the matters pleaded by the proposed representative, and Her Ladyship decided in that case that the matters that had been alleged and pleaded would not of themselves have constituted a cause of action on behalf of each member of the class, and therefore the representative action wasn't allowed to proceed. And in that case, she was concerned with both issues of liability and quantum, so looking at both whether liability could be established on a common basis and then loss. That takes me then on, I think, to the judge's judgment in the present case, which you've got at page 81 in the core bundle. I'll try and take this as speedily as I can. Your Lordships have no doubt looked at this already, but there's the judge sets out an introduction, paragraphs 1 to 12, and then refers to definitions of the class in paragraphs 13 to 16, refers to the terms of business in paragraph 18. Perhaps I could just pause there because I'm conscious I haven't actually shown your Lordships the terms of business, but the judge has set those matters, the relevant passages out. So if your Lordships can see, this is page 84, paragraph 18. Pursuant to clause 2.2, M&C undertook to practice competently, conscientiously and objectively, and to put the client's interests foremost and to avoid conflicts of interest. And then paragraph, clause 4.1, M&C notified its clients that it might be necessary to instruct third parties to act on their behalf. And clause 4.2 stated that it endeavoured to select third parties whose performance and expertise regarded as being of good quality. Then 4.3, services did not extend to issuing reminders for and processing renewals of any of the client's IP rights absent contrary agreement. However, its standard practice is to pass details of all cases we handle requiring such renewal agents. And the terms of business granted M&C an authority by which the client agreed in each case to authorise authorise M&C to instruct CPA to remind the registered proprietors concerned or their appointed representatives of due dates for payment of renewal fees. That authority was provided under the general rubric instruction of third parties to act on your behalf. And I make the point, as I made this morning, that that's not properly construed, we would suggest, an authority to M&C to actually engage CPA on a client's behalf. It's merely an authority to pass information to CPA to enable CPA to remind the clients of the due dates for payment of renewal fees. And then paragraph 20 in the judgment foot of that page, I should record that the defendants emphasised their case that Bambatch Europe was not in fact referred to CPA by the first defendant, contrary to the particulars of the claim originally pleaded. The full ramifications of this are not clear, but there remain the facts on the claimant's case that the involvement of the first defendant with CPA and the receipt of commission by LAR from CPA were not disclosed. The claimant has also an assignment from another client, Fire Angel, to use if Bambatch Europe has no claim. Just starting with that last sentence, with respect, it's not clear what the judge meant by that. It's true, of course, that the claimant does hold that assignment, but if as the judge allowed, the case was to proceed on the basis of the 19.8 process and Bambatch's claim failed, then necessarily all clients' claims have failed, including Fire Angel. It's no part of the process under 19.8 for there to sort of be a test case, as it were, see what happens with that, and then perhaps somebody else can pop up and say, well, my case is different. How about we try my case? The premise is that Bambatch's claim is a common claim with the members of all of the class, including
They could apply to add Fire Angel. They could apply to amend their pleadings to make Fire Angel the representative party.
They could, my lord, but that, in our respectful submission, would demonstrate why 19.8 is inappropriate. The only reason that they would propose to do that would be some 19.8 difficulty of pursuing Bambatch's claim. What they then did was to add Fire Angel's claim. That would just multiply the difficulty, because it would be an admission that Bambatch's claim was not sufficiently common with the other the claims of the other clients to warrant 19.8. But why would adding Fire Angel make any difference?
Well, not to this appeal. You say we're here engaged on an appeal in relation to Bambatch acting as representative claimant, not somebody else who hasn't yet been added.
Indeed, my lord. And so, I mean, your lordship's right. The appeal is the appeal against the claim as it's advanced by Bambatch. There's no suggestion of any desire on the part of the claimants to wish to add Fire Angel.
But my lord's point is that you attack this on a wide range of fronts, one of which is the identity of the particular representative, but you also have a number of other arguments which actually, I think you say, would apply whoever it is.
Well, yes, my lord.
So it's both.
And it's just, it happens to be our Bambatch we use as an illustrative example of a case that might not fit the vanilla mould. It happens to be that it's the claimant, but it could just be a member of the class that we'd pointed to. So adding Fire Angel in our respectful submission wouldn't avoid any of the difficulties that we've identified.
Right.
The second point about those paragraphs is that they are, in our respectful submission, in the context of the application we were made, wholly inadequate. It's of course right that the full ramifications aren't clear in the sense of it's unclear what would happen at trial, and points we make about Bambatch are points that would have to be resolved at a trial of its claim. But that's not the point with respect to the judge. The point is whether the nature of the claims, including Bambatch's specifically, are such that the court should have concluded at that point that the claims weren't common. And it's that issue that the judge should have grappled with, but simply didn't. No good in our very respectful submission to sort of just push it off on the basis that the ramifications weren't clear. So that's 20 and 21. He then refers to Wood in some cites detailed sections from Wood from paragraphs 20 to 25. And then 26 to 43, he deals with our Champty strikeout application, which, as your lordships know, is not being pursued. If your lordships then go on to paragraph 44 on page 93, there he refers to what was then 19.6 in paragraph 44. He quotes passages from Lord Legate's judgment in 49 and 50. But we would ask you, and the quotation on page 94, paragraph 50 is paragraph 69, 71 and 72. What he doesn't do is to refer to the section in which Lord Legate says that the premise of a representative action is that there are common issues of fact and law. That he hasn't cited. He then sets out various of our contentions from paragraph 51, but not in fact the points that we were making about individualised assessment. And if your lordships go on to 56, it says the points above from the statement of case and submissions on behalf of the defendants are only a summary. It is the summary of a comprehensive attempt on the part of the defendants to identify issues facing clients of the first defendant, including differences, complexities and difficulties. But what matters is whether the same interest requirement is met, and in particular whether the points involve class members affected by an issue prejudicing the position of others. None do. But he doesn't there address at all the question of whether the claims are common or there's a need for individual assessment. 58, he refers to the points about the dates of the contracts, says that those points do not affect suitability if representative proceedings can be ascertained. And then he says it is clear enough that the class is only intended to comprise those to whom the commission was not disclosed. Well, in that respect, the judge was clearly wrong. As your lordships saw this morning, the definition of the class in paragraph 8 is not one which is cast by reference to whether there had been disclosure to any particular person in respect of the commission. And that must on any footing be a matter which is in dispute in the proceedings and therefore dependent upon the outcome. And so in that respect, the judge was, in our respectful submission, clearly wrong. And he clearly wrong to proceed on the basis that the claim was only being made by people to whom, by definition, the payment of CMF had not been disclosed. He then deals with our point about limitation in 60 through to, in paragraph 60. This is now a subsidiary point in that the first trial isn't going to consider questions of limitation in respect of members of the class other than Bambatch itself. But nevertheless, in our respectful submission, the judge was clearly wrong in what he said in respect of limitation, in that the way in which the matter has arisen on the pleadings is that the defendants have taken a limitation point. The claimant has accepted that prima facie there's a 6-year limitation period, but relies upon section 32. But in the context of section 32, the burden of proof is established on the case law to fall on the claimant to plead deliberate concealment and that plead the date of discovery and plead that the relevant matters were not discoverable. The burden falls on the claimant to assert those matters. And so on any footing in our respectful submission, it can't possibly be right for the limitation issue to proceed on a representative basis because the claimant isn't in a position to be able to plead in respect of any particular member of the class a case on deliberate concealment or the date of discovery by that class member, or plead anything in respect of the discoverability of the relevant matters by that class member. And so in our respectful submission, this court, or whatever other findings it makes, this court ought to decide that that issue of limitation, that is limitation as it affects members of the class, is not a matter that is suitable for determination under 19.8.
Well, not sure I follow that. I mean, deliberate disclosure is primarily aimed at what your clients did or did not do until they amended their terms of business to openly disclose what they were up to. I mean, it certainly can be said, well, this was not disclosed. There was nothing in the terms of business. A claimant can say, I knew nothing about it until I received the 2018 terms of business.
And Bambach pleads that case in its own right, but it can't plead, and it's now jettisoned any attempt to plead anything broader. It can't plead what was disclosed to any other member of the class, or the date on which that member of the class discovered the relevant matters.
But the deliberate concealment is by your side, i.e. you impose duties of confidentiality in your arrangements with CPA, or you were subject to duties of confidentiality. We saw that earlier, which presumably you abided by.
Well, the evidence is that there was at least one occasion on which disclosure was made, and Mr. Kenrick's evidence is there may well have been other occasions in which disclosure was in fact made. I should have made the point this morning, as your lordships raised it, is that the obligation of confidence was subject to a right to disclose where the law otherwise required. So I'm not sure that in the end the terms of business take one very far. It's true on their face that there's an obligation of confidence, and we accept that there was no general process for disclosure until the terms of business were amended in 2018.
But going back to my Lord Master Rolls' point to you earlier, I mean, the fact that there might be individual people who happened to find out or to whom ad hoc disclosure was made might, to use I think Lord Legate's what he envisaged, result in individual points. But why does it make the formulation of a class wholly inappropriate to start with if the overwhelming majority of people who were subject to the T's and C's or the terms of business and this relationship were simply not told, and you were under a duty of confidence not to tell them?
Well, because one can't identify across the class which of those people were the people to whom disclosure was made.
But in paragraph 58, Lord Legate makes perfectly clear that you can bifurcate and decide if you can leave over the question of whether there's a defence in a particular case to later. But you can't just push this whole procedure onto the back burner and say it can never be used where there might be an individual defence, because it would never be capable of use. I mean, that's not your case, is it?
Well, I don't put my case as high as that, my lord. But the point that arises here is...
I thought you did, actually, because you said... I mean, sorry, but I thought you said the fact that there's a limitation defence here raised by your side meant of itself this is wholly inappropriate.
No, my lord. If I wasn't intending to go that far. I was addressing, and maybe I should have made myself clearer in saying what I said about limitation. I'm addressing the question about whether limitation is a matter that can go forward on a representative basis.
Do we need to decide that?
Well,
because, as you said, it's not currently an issue for the first trial. And as I read the judge's judgment at 61, he accepted that it might well be the case that limitation would have to be done on an individual basis, although he says it may not be necessary.
Okay.
That's a future question. So do we need to decide anything about
Well,
limitation?
Well, my lord, I think my submission is that it would be preferable for that point to be made clear now, but that there is no absolute necessity.
Do you take issue with what the judge says at 61? There may even be some clients for whom a defence of limitation taken by the defendants will in due course require individual arrangements outside CPR 19.6. That's right.
That's right, but the point which is missed in my respectful submission is that it's never going, the process that's underway is never going to be a process which will reveal which of the clients has limitation defences that can be dealt with, or rather must be dealt with on an individual basis. There's
But
simply
there will be some clients, because the class runs up until 2018, there will be some clients for whom some of the commission payments will have been made within the previous 6 years. When does the 6 years stop running? Is there an issue there?
There's not an issue about that, no. So prima facie it's accepted that it's 6 years back from the date on which the proceedings were issued, which was 2021.
I mean, do you accept 61 is correct or not?
I don't accept 61. So well, I don't quarrel with 61 as far as it goes, my lord. No. My point, and maybe I'm creating a hurdle for myself that's unnecessary, is that this court ought to grapple now, given what's said in the judgment, with the question about whether in the future limitation is something that can be dealt with on a class basis. But I accept that this court could reach effectively a case management decision to say, well, the judge has parked it. We're not minded to unpark it at this stage, and it's an issue that can be come back to.
Right, so just to be very clear, because I thought you had submitted to the contrary, the last sentence of 61 is not your position. So you're not saying that the last sentence of paragraph 61 is wrong?
Well, it depends on, I'm sorry to be difficult, my lord. It depends whether what we're talking about here is 19.8, so far as only it concerns limitation. I'm certainly not making a point that limitation has some sort of magical effect to render the entirety of the claim unsuitable for 19.8.
No, but if you accept this as being right, then it seems anyway to me, arguably, to follow that the question of fully informed consent, just to use that as shorthand for all the consent issues, could also be parked.
Well,
and is not fatal to the representative action.
no, my lord, I certainly wouldn't accept.
What's the difference?
Well, the question of informed consent and the question of knowledge have to go together.
No, I accept that. Sorry,
And
I use fully informed consent and knowledge as part and parcel of the same issue. So let's.
Well, my lord, there's a very short point in respect of that. So
yeah.
Knowledge is significant in two different ways. Knowledge is relevant to whether a disinterested advice duty of the relevant kind is owed at all. That is, we would say, deciding liability, when one's looking at what conflicts of interest under the terms of business is referable to, whether M&C was under a conflict of interest.
So do you say it's relevant, one, to whether there's a duty at all, and two, whether there's a defence?
Well, it's probably threefold then, my lord. I apologise. It's relevant to whether a duty was owed at all, so it's relevant to liability in that sense. It's relevant to whether the tort of bribery was committed, in the sense that our submission is that secrecy is an element of the tort, and so if a client had knowledge, then the tort can't be committed. That's the second point. And then the third point, which is obviously follows on closely, is that knowledge goes to the question of informed consent. And I accept that that's a question which is whether there's a defence to a claim for breach of fiduciary duty. But knowledge percolates across all of three of those points.
Just in a sentence, how is knowledge relevant to the question of the existence of a duty?
Well, because if a client knew of the payment of CMF, that's one part of the context which the court would have to inquire into under what we say the law is up.
The duty not to take a secret commission is a duty not to take a secret commission. If it's not a secret commission, if it's not secret, it's not a secret commission.
But the question as to whether it's a secret commission depends upon an analysis of the role of the agent, what the agent's actually being asked to do.
Well, I know you say that, but I'm just exploring it, because it seems to me that if I instruct you to ask somebody to do something for me, and whatever your terms and conditions are, if you then take a secret commission from that person for giving that person the work, you're liable to me. And I don't see really, I mean, that seems a very simple proposition as a lawyer. I mean, yes, you can explore the relationship till you're blue in the face, but if you take backhanders, Mr. Mitchell, then backhanders are not really favourably regarded by the law.
No.
So the nature of the relationship doesn't entitle you to take backhanders, just to put it in colloquial language for a minute, so that we understand what we're talking about. You can dress it up in all sorts of nice ways, but you shouldn't be doing that.
But your lordship's example, the fact pattern of your lordship's example, is a fact pattern which would lead to a finding that there was a relevant duty. In the Bambatch case, Bambatch instructed M&C to enter into record the assignments at the relevant IP.
Maybe they didn't take backhanders in Bambatch. That's a separate argument. I'm just talking about whether or not knowledge really goes to duty. There is a duty not to take a secret commission in a relationship between X and Y in relation to intellectual property, as in this case, isn't there? I mean, you can't get away from that. You don't say to me it's all bound up in Lady Justice Asplin's wonderful exposition of what happened in that very different case.
Well, my lord, I do.
Yeah.
Because we can use Bambatch as an example. The retainer of M&C was to record the assignments. Bambatch Europe then, on our case, made its own decision to instruct CPA. And we don't happen to allege in that particular case that it knew of the CMF arrangements. But the debate at trial is going to be whether the fact that the retainer was simply to record the assignments, coupled with the fact that it made its own decision about whether to instruct CPA without reliance or placing any trust in
you can take a secret commission, can you? I mean, you weren't acting for
but the point, my lord, is that merely because we were acting in one capacity doesn't mean that that any payment is any payment that's received is properly characterised as a bribe or a secret commission. It depends upon an analysis of what the retainer was for, what work was done.
Do I need a contract with you in order to perform services? Let's say you come to me and say, will you help me out with this? And I say, yes, out of the goodness of my heart, I will. And then I say, what about you go to Lord Justice Nugee to do something else for you? And you say, oh, that's a good idea, thank you. And I don't tell you that Lord Justice Nugee is giving me a large backhander for this recommendation. I mean, does it depend on any of these terms and conditions? I mean, the fact of the matter is that is a fairly common understood principle that if I'm saying I'm helping you out, I should owe you some duty of loyalty.
Well,
and not to take a secret commission.
I'm not sure I quarrel with your lordship's example, but your lordship's example gives rise to liability because there was on your example, there was a recommendation, and the recommendation
What's the
connected
difference between agreeing to record an assignment and agreeing to do anything else?
Well, the recording of the assignment's got nothing to do with the renewal of the IP rights.
Yeah, but why does that matter? I mean, if I say, look, you've asked me to help you out to go and buy a television, but what about I get my good friend Lord Justice Nugee, who fits aerials, to come and help you fit an aerial? And I don't tell you that he's giving me a massive secret commission. I mean,
but then the question would the question to which that would then give rise is whether I'm reposing trust and confidence in you in that particular respect. It may or may not. That it would depend upon the facts. If the matters were completely unconnected and I wasn't in any way relying upon the advice you were giving me about aerials or who you were recommending or referring
I mean, the
for errors,
the
then
problem with analogies is always the case that you could say, that you could be right, obviously, depending on the relationship. But if you're a trademark, if you're a patent attorney, then it's perfectly obvious that you repose trust and confidence in the expertise of the patent attorney. It's a rather different thing from a television expert or, television salesman, really.
well,
I mean, I think it's important just to have this discussion, because I don't think it's absolutely obvious that Bam Batch is a case where knowledge is relevant to the duty. It might be, but I can see that it's still arguable.
well, and that ultimately is the point. I mean, we advance a case in our defence that the content and scope of the duties depend upon all of the circumstances. That has not been struck out as being legally irrelevant.
Well, there's not been an application to strike out.
No.
No, but I think you are asking us to decide that in your favour.
No, all I'm asking you to do is that it's arguably relevant to a decision as to whether or not there's a bribe or secret commission liability in respect of any member of the class. That's the point. The point is that can the court now see that the facts that Bam Batch pleads necessarily means that if they win, everybody wins? And our point is that you can't answer that question in the abstract by reference to one case.
I have some trouble with this, because picking up what's just been put to you, on one view, Bam Batch should be the ideal claimant for you, because it has a defect in its case which you've identified, which could lead to everybody failing, because you can knock Bam Batch out. If we forget the Bam Batch Australia bit for a second, we just looked at the clauses of the contract that everybody signed. You've got a clause that says you undertook to practice competently, conscientiously, or objectively. You have another clause that says, but when our services, which is an important definition, doesn't include handling reminders for renewals, but here's somebody who, unless you tell us otherwise, we're going to give your details to so that they can approach you to do it. But we don't tell you that they're going to pay us, or somebody related to us, a commission. Now, if we just had that fact pattern on those contractual provisions and nothing else, actually your case is a more difficult one than it might be against Bam Batch, who you at least can say, well, they weren't relying. So I'm slightly struggling to understand why a case couldn't be put just on the basis of those contractual provisions, setting up the framework, which wouldn't cause a problem. There might be an individual case in which somebody might actually be subject to a particular defence, like Bam Batch, but I struggle to understand why you're so keen to knock Bam Batch out, when in truth they might be the perfect vehicle for you to win against, and then knock everybody out who doesn't have the same deficiency.
No, but my lord, with the greatest respect, that misses the point. It's not a question of us trying to knock Bam Batch out now. Bam Batch is relevant because it illustrates why you can't simply determine whether the relevant duties were owed and whether there was a breach by reference to the generic matters, by reference to the terms of business.
But the generic
it's an example of why.
But are you saying? I mean, you're saying, if I've misunderstood it, you're saying that the generic plain vanilla person who did nothing else but sign the terms of business and then just sat there and paid up when CPA approached them, that you're saying you couldn't mount a representative claim just on the basis of that, and then the argument would be, do those provisions give rise to a duty to give independent advice or whatever?
But how could you set up a?
Well, why not? Everybody signed it. You defined the class because it's defined by reference to everybody who signed those terms of business between two particular periods.
But this comes back to the example this morning. Say Bam Batch hadn't been the claimant, a vanilla client was the claimant, and we were having this debate. But we happen to have Mr. Kendrick, who happens to have known about the Bam Batch situation. So he leads evidence and says, well, yes, the claimant, we think we have a defence against the claimant's claim, but that was, the claimant's claim on this example was the sort of standard arrangement. But not everybody was in that position. See Bambatch. So Bambatch is somebody who contracted on the terms of business. But Bambatch is a client where we say we have a bespoke defence because of what happened. So
why can't you just make an order along the lines my Lord's suggesting, that on the premise that you signed the conditions that a secret commission was taken, there is liability subject to specific defences. And then when any particular claimant comes to claim damages, i.e. the commission that was paid in his or her or its case, it's up to you to say, because you're the only person who can possibly know, you knew. And before you have the opportunity to raise that defence, you don't have to pay the damages. I mean, that's the kind of thing that Lord Leggatt is envisaging in paragraph 58.
But that would involve a bifurcation within the question of liability. It would be to say, we're just going to the court's going to put its hands over its eyes to the circumstances and determine this by reference simply to the terms of business, acknowledging that perhaps in the case of some members of the class, liability can't be established because they knew or
That's
they
what
consented.
Rachel Mulheron was saying, as approved by Lord Leggatt in paragraph 58. You can take specific parts of what might be a defence to liability and try them separately if they arise.
But it's not just a question of a defence in that sense, my lord. The court's got to decide whether the tort of bribery was committed or a breach of fiduciary duty was committed. What your lordship is positing is proceeding to declaratory relief, where the court doesn't go that far.
But they would say, I suppose, I mean, I'm just drafting, but they would say, we declare that if you signed up to use M&S as M&C as a patent attorney on these terms, and M&C recommended you to, I can never remember the initials. CPA. And a secret commission was paid to CPA, there is liability subject to any specific defences of knowledge or whatever.
But subject also to the question about whether or not the disinterested advice duty was owed in the relevant circumstances.
I mean,
that is the heart. That's the heart of it. But can I just make one very specific point on what your lordship just said, which is that your lordship's declaration included the suggestion that any client who had been referred to or recommended to CPA. But that's not Bambatch. Bambatch is not making that case.
No, I know that.
It's had to drop that, we say, because of Mr. Kenrick's evidence to say, well, we didn't refer you. So what your lordship's proposed as an example cannot happen in this representative action because...
No, but I'm asking you whether it could happen in theory in another world on your submission.
It can't happen, my lord, no, in our respectful
It can't.
submission.
So where is the line to be drawn? What did Lord
Liability
Leggatt mean in paragraph 58? There has to be liability. So you have to be able to try every aspect of liability and all defences to liability with common facts.
Well, I'm not sure I would go...
Because you just accepted that limitation. I mean, limitation goes directly to liability, and you've just accepted that that can be left over. What's the material difference between limitation and any other defence?
Well, because you've got... There has to be a point at which the bifurcation... You have to stop at some point and identify something of sense to resolve. A question as to whether the tort of bribery has been committed or whether there has been a breach of fiduciary duty, those are matters that the court can try on their own. Bifurcation can narrow it to that point. But certainly in a case like this, you can't then start taking your scalpel and cutting liability into pieces.
But you are, if you accept 61.
limitations of procedural defence, which sits separately, my lord, at least for these purposes.
Limitation goes to the heart of it. You're not entitled to any judgment if you have a limitation defence.
No, but you can you could in principle ask for a declaration as to
What
liability.
declaration do they ask for here?
They ask for a declaration as to liability for each of the causes of action that they pursue.
Without reference to any defence or...
I think it just doesn't. Well, it just says that it doesn't
We'll
say.
check it up. Sorry, my lord wants to ask something.
I just wanted-
His personal...
No. This may be going back to a point that I've already raised, but it's the claimant's case that despite the peculiarities of the Bambatch situation, facts in Bambatch, which don't appear to be in dispute, may not be in dispute, nevertheless, you owed them a relevant duty and you broke it and they're entitled to an account of the commission. They may be right or they may be wrong about that. I, for my part, think that's a question for trial, not a question for us. If they are right about that, then would it not follow that they would also be right? That if that was the case in the Bambatch case, it would also be the case in much simpler, more vanilla or more straightforward cases. In other words, they've set themselves quite an ambitious target to show that even in the Bambatch case they can recover. If they succeed on that, then does not liability for much easier, simpler cases follow? Whereas your cases, in Bambatch, you didn't have any relevant duty, so you're not under any liability. And if you're right about that, then obviously Bambatch can't serve as a representative for anybody else, save, and as my lord pointed out, you may be able to get everybody's case struck out on that basis. But one of the issues currently on the list for the trial is whether there is any distinguishing feature between the Bambatch type fact pattern and other cases. Why can't that be left to trial? That's what I'm struggling with. I'm very unhappy about us being asked to decide today something that seems to me to be naturally a case for trial, which is find all the facts and decide what duty on those facts was owed and whether there was a breach on them. Whereas you're inviting us to say we can today decide that the fact patterns make a difference. And I'm very reluctant to come to that conclusion.
Our principal point, my lord, is that we say that it's not appropriate for a court to permit a case to proceed under 19.8, where the court can see that the issue that's being pursued on a 19.8 basis is one where the court has to examine whether the relevant duties were owed and breached on an individual basis. And we do say the court can reach a conclusion now that's at least arguably right. But if it's arguably right, then the cases are not common.
It's at least, well, you're inviting us to say these cases are not common. Bambatch is not common with the vanilla case. And we're going to be invited to say, well, hang on a minute. On our case, the claimant's case, Bambatch generates the duty and a fortiori duties generated in other cases. But so we can't decide whether they're common or not without resolving that question. But that doesn't seem to me to be a matter for this stage. It seems to be a matter for
our submission is that
it is a matter for this stage.
It is, yes. But there's a further point, my lord, which is that as certainly my learned friend side envisages it, I think the order the judge has made is unclear, but the trial direction appears to be a trial direction, that the court at trial will only consider the matter by reference to the terms of business and not the Bambatch specific circumstances.
Oh, I see.
So what's proposed is that we're not allowed to run the argument that I've been advancing to your lordships this morning. And because the judge was concerned, well, that doesn't feel like a class issue, and it's not. But in our respectful action submission, that shows why 19.8 is inappropriate.
Well, no, but can I just turn that on you, as it were, to be fair? Incidentally, where everybody's been talking about Lloyd and Google, I think what Lord Leggett says at the beginning of 81 makes explicit the possibility. It's 81 where he says, common issues of law fact are decided through a representative claim, leaving issues which require individual determination, whether they relate to liability or the amount of damages, to be dealt with at a subsequent stage of proceedings. So I'll just put that into the transcript for a second. But if the claim against you was limited to the question, the issue, does somebody who has signed your standard terms of business in the format that's pleaded, and in respect of whom a commission was paid by TPA to the partnership, do they have a claim in bribery or for breach of fiduciary duty? Why? So I'm putting aside the Bambax question just for 1 second. Just assume that was the claim against you. Is that inappropriate for a representative action, and if so, why?
Can you just put the...
It is something that just says the class is anybody who signed terms and conditions in the form that's pleaded containing the relevant provisions and in respect of whom a commission was paid by TPA to the partnership. That's it. I mean, why cannot the question of whether that gives rise to a duty or constitutes bribery be tried as an issue which affects all clients who signed those terms and conditions with you during the relevant period, and then leave over questions of whether there might be any first of all, quantification, secondly, limitation, thirdly, any individual circumstances which might deprive one of your clients of that cause of action.
But what your lordship's proposing is an issue where you've taken a scalpel to the question of liability. Because your lordship has posited an issue to go forward for a trial, which wouldn't be a question about whether there's liability, because liability, this is our submission, can't be resolved purely by looking at the terms of business. And so what your lordship's proposing is that any client-specific circumstances that might affect the existence of the relevant duty would be left on one side.
Well, what are you, but other than the very odd Bambax situation?
But why are you? But with respect, my lord, why are you treating it as if it's just an example on its own?
Well,
why can't it have arisen multiple times out of thousands of clients? I mean, or what about clients that that through knowledge, because they've talked to somebody else in the industry, knew full well about CM?
All those things go to defence. I mean, the point is, if a plain vanilla client against whom there are no such in relation to which there are no such factual circumstances, doesn't have a cause of action against you because reliance on the terms and conditions just doesn't give rise to a duty, because you've excluded from the definition of services anything to do with renewals, for example, and you openly said we're going to tell CLA, and so everybody, I think, as you would say, has no expectation of reposing trust and confidence in you about how good CPA are, if that's the line of defence. Why can't that issue, which is common to everybody, be tried on a representative basis? You might have additional particular bespoke knowledge arguments in relation to individual clients, because Joe Bloggs told Joe Soap, oh, and by the way, we're getting a nice little kickback from CPA, but that would be at a later stage. That would be an individualised issue, but the big issue is whether this arrangement that you put in place gives rise to the duties or falls within the concept of bribery at all?
Well, my lord, my answer to that I think has to be twofold. But first of all, there has to be, in our respectful submission, a limit to how finely one bifurcates a point for it still to be a common issue for the purposes of the rule. And what your lordship...
What is the limit?
Sorry, my lord.
What's the limit?
Well, the limit. I mean, that has to be looked at in the particular case. And in a case like this, the limit has to be, we would say as a matter of principle, that where the cases, the pleadings draw issue in a way which gives rise to an issue as to liability, which extends beyond the terms of business. It's wrong in principle to identify an issue, a partial issue of liability to be dealt with on a class basis. So that would be my starting point, is that it would be wrong in principle to go that far. My second point in response to my Lord Justice Snowden's point is that one then becomes, if one is contemplating doing that kind of exercise, then one is drawn deeply into whether or not, as a matter of discretion, that is appropriate. In Lloyd and Google and Prismal and Google, the funders wouldn't have had any interest in that whatsoever. I mean, not just is it not determining quantum, it's not even determining liability necessarily in respect of any particular client. It's just one issue.
No, they wanted money.
Sorry?
They want
money.
Yeah,
but
but
it doesn't
that may
even
not be the case here. I mean, it may
well,
be, I have no idea.
Well, we don't know. What we say about that is that the client class here has there's no obvious interest in that class having a partial declaration of liability on its own. It's not an injunction case. There's no benefit. No one's suggesting there's any benefit per se in there being a declaration as to liability or declaration as to part of liability, which is my lord's suggest. Well, my lord, let me just.
Well, I think you need to make progress now.
Sorry,
you were at paragraph 61 in Mr. Justice Knowles' judgment when we stopped you. I stopped you, to be specific, and I don't know how much more you've got, but I think we have teased out many of your submissions.
You've teased out many of my submissions, my lord.
Those exchanges.
I mean, I have a
we
little
do
way.
need to know specifically which paragraphs of Mr. Justice Knowles beyond 61 you say are wrong.
My lord, yes, or at least identify the paragraphs where he doesn't make necessary relevant findings.
Yeah.
I need to do that, my lord. Shall I do that and then come back to the other points?
Why not?
Paragraph 62 deals with election. I'll make a very specific point in my submissions about that. I won't hold your lordship up on that at this point. There's then a point in 63 that the judge makes about reliance on the claimant as a representative party and pursuing vigorously lines of argument not directly applicable to the claimant's case. I mean, I'm not sure it necessarily goes very far, but we, with respect, don't understand how that really arises in a case, at least of this kind, where the claimant simply isn't in a position to pursue lines of argument not directly applicable to its case, but as I say, maybe nothing turns on that. And then 64, standing back, the points include those that will require care, but each is capable of resolution, none is fatal on jurisdiction. They will inform discretion, as will other material circumstances, but there is no absence of same interest. So he's finished there on the question of same interest, and he doesn't address the points that we make about common claims or individual assessment. He then goes on and deals with discretion, cites paragraph 75 of Google at paragraph 65, and then other paragraphs. And then if you go down to the foot of 99, he refers again to passages of the defence and counterclaim, but those are passages that relate to discretion rather than individual assessment. And then from 67, he tries to draw the points together so far as discretion is concerned. 68, he says, the first thing to say is that it is not a requirement of 19.6 jurisdiction that the proceedings will necessarily resolve all possible claims. What he means there is not claims within the proceedings. He's responding to a point that we make, that there may be other clients with other claims that are not included within this claim. Paragraph 70, from the available evidence, it's not clear to me that, as asserted by the defendants, the clients do know about the payment of commission, either as a result of the amended terms of business or in any event. I acknowledge that some may, but the defendants are better placed to know which, or to provide a channel of communication to find out which. Well, that we say misses the points that are made in Mr. Kenrick's evidence about clients acquiring knowledge of the arrangements from sources other than M&C itself, in respect of which it's simply impossible for M&C to undertake any kind of inquiries of its own. But, of course, if we were being faced with an ordinary claim by separate members of the class, it would then be possible for us, in response to individual claims, to make inquiries and to test the way in which the claims are being advanced, including by reference to disclosure being provided by particular clients. That's simply not something that's open to us in a process of this kind.
But it would be if there were a caveat subject to individual defences.
Yes, the proposal my Lord Justice Snowden makes seeks to narrow matters down to avoid that, at least at this stage. And I'll come back to at least at this stage when I address your lordships on discretion. Then 71, I think, is the closest he gets to making a determination in respect of individual assessment. But in our respectful submission, this is directed at, properly read as directed at quantum rather than liabilities. There's a claim for undisclosed or secret commission is perhaps a reasonable example of a claim where an entitlement can be calculated on a basis that is common to all members of the class. The fact it appears the commission varied between clients does not deflect that from that point. In any event, there are still present at least some of the advantages in terms of justice and efficiency if common issues of law or fact are decided through a representative claim. So we would respectfully suggest that's directed at quantum rather than liability. He doesn't, in that paragraph, identify in any event, beyond the possibility of quantum, what particular common issues there are that are suitable for determination under 19.8.
I mean, it can't, whether he says that or not, as my lord has already pointed out, the quotation expressed that he is common issues of law and fact are decided through a representative claim, leaving over issues actually then goes on to talk about whether it's damages, liability or damages. So he's quoting from something that makes it very clear it can be liability and it can be damages.
That's right, my lord, but he doesn't undertake any analysis in response to the points we made about
no, I accept that. Yeah.
And indeed, that just doesn't appear anywhere.
No.
And as I think I said this morning, in a sense, it's an hour debate now as to whether properly construed his judgment decided against us the points that I make about individual assessment or not. I mean, they are points of principle, and we're before this court and say that either he didn't decide it, or if he did, he was wrong. And we make our arguments, and your lordships either accept them or they don't.
Yeah, fair enough.
There's then a section that deals with net recovery, but that's not recovery by the clients. This is what happens if sort of recoveries are made and issues arise as to what remuneration should go to the claimant or the representative or the funder. So those aren't points, I think, that your lordships need to consider on this appeal. And then over the page 76, I do consider that in the present case it's realistic and appropriate to accept the focus can be on the recovery of commission rather than other remedies. And then there's a reference in 77 to my submissions in respect of the need for disclosure, and I was making submissions to the judge about the fact that we would need disclosure from Bambach for there to be a fair disposal of the Bambach claim was an illustration of the broader points that we were making about why that made it unsuitable for a representative action. And then 78, he says, looking ahead, some information or choice from each client may be needed or highly desirable. And then 79, but it's possible that the litigation could break down if the clients were unresponsive at later stages. And 80, each case turns on its own facts and circumstances. And then 81, nonetheless, taking this present litigation as it stands, including the points raised by defendants under the jurisdiction, also informed discretion, focused as it is on the recovery of undisclosed or secret commissions rather than damages requiring individualised assessment. I have reached the decision in the exercise of my discretion to allow the claimant to represent the class and to do so on the opt-out basis proposed. If the choice is this or nothing, then better this. And then at the end of 83, if appropriate, the defendants may ask the court to look at the position under 19.62 again. The provision is not once and for all. Provision is dealing with a question that may be of continuing relevance, and that question may be re-examined where appropriate. Obviously, re-examination will not be suitable where the points are simply the same. And then 85, he addresses the point we make about the particulars of claim. He says they're sufficiently pleaded in the sense that I've been able to work with them. I'm satisfied the defendants know the case that they have to meet. I do not believe, as the defendants contend, that it's necessary for the particulars of claim to be extended to plead member by member the facts and matters that would constitute a cause of action on the part of each member of the purported class. It's clear enough that what is pleaded is, in essential terms, the same for each member. If that is not clear, it can be addressed by amendment. So we specifically say that's wrong, and I'll make my submissions on that in a moment. And then 90, I propose to direct a case management conference. The party should liaise, and then there's an end note, which I don't think I need to ask your lordships to look at. So, my lords, I think that takes me to try to draw together our submissions by reference to each of the grounds of appeal. Ground 1 raises the pleading point and ground 2 raises the individualised assessment point. Those two grounds, we would suggest, are two ways of looking at the same point. The judge was wrong in our respectful submission to suggest that it's not necessary for the representative to plead the facts and matters necessary to make good the claim of each member of the class. That's precisely the exercise that let me start that point again. Lord Leggatt didn't address that point specifically in his analysis on the law, but the way in which he undertook the analysis of the particular case before him made it clear that what he was undertaking was an analysis of deciding whether the facts and matters advanced by the representative were necessarily good to make good the cause of action of each member of the class. And the judge's suggestion to the contrary, we would respectfully suggest, was wrong. So there is, we would suggest, a need to plead facts and matters that cover the claims of all of the members of the class. And in our respectful submission, what the claimant has done in this case is not adequate. And what we suggest is that in order to plead a proper claim that covers the claims of all the members of the class, it would be necessary to plead the terms on which the relationship was formed, the purpose for which M&C was engaged, the facts and matters said to give rise to the relevant duties and the scope and content of those duties. In particular, to plead a claim in bribery or breach of fiduciary duty, the claimant, or a claimant, must plead the facts and matters said to give rise to the disinterested advice duty, and to do so by pleading the facts in the circumstances in which the particular client retained M&C and instructed CPA. All of that constitutes a proper plea in bribery and breach of fiduciary duty. It's also necessary, we suggest, to plead that the payments were received by M&C at a time when the client did not know about the payment of CMF. In other words, it's necessary to plead that the payments were secret. And the claimant hasn't done that.
Did you say, I was trying to write it down, when you say didn't know about CPA, I don't think you quite mean, you don't mean that, because everybody knew about CPA, it was on the
Sorry, CMF, the commission. So it's the time when the client did not know about the payment of CMF, payment of the commissions. Sorry. The claimant hasn't, and obviously can't plead those matters in respect of the claims of any of the class members other than itself. It's simply not good enough in our respectful submission to plead the terms of business and to plead that there was a duty to avoid conflicts of interest without pleading.
So you could never have a representative action in bribery, basically.
That may well be right, my lord, but if so, so be it. There are inevitably some kinds of claim which are unsuitable for this process. I mean, the legislature has provided, by the group litigation provisions, specific processes by which, but by omission has decided not to provide a class action process of the kind that one sees in competition appeal tribunal. So we are left in a world in which the legislation has not changed the basic tenets of our procedural law. It is still necessary for somebody who seeks a remedy, whether just on behalf of themselves or on behalf of others, to plead the necessary facts and matters and then to prove them at a trial. It's just not adequate in our respectful submission for there to be a plea simply of the existence of the terms of business and the fact that that client contracted with M&C on those terms, because all the terms of business do is record that M&C was under an obligation to avoid conflicts of interest. In order to allege that there was a breach, any particular client would obviously have to go further. And where we've ended up is that the claimant is, we would say, being driven at the judge's invitation to adopt what we would suggest is an inappropriate lowest common denominator approach. What it suggested is, and on one view this is what the judge has ordered, is that there should be a trial of the tort of bribery, but in circumstances where one of our hands is tied behind our back. We're not entitled to advance the case that we advance in the pleading about Bambatch's specific circumstances.
So, in a sense, why is that? I mean, you would say that nobody gets off the ground unless they could establish on a plain vanilla look at the terms and conditions assume nothing else. I mean, I went down your list. You'd say that if somebody couldn't get the case off the ground on the terms of business, that they don't even get to first base. You just keep your second punch back for the follow-on. And if you win on the first sort of narrow way the case is put the issue on the terms and conditions, you win. Even if you lose, you have your second fight, which is to say, on the particular facts of this case, or indeed a large number of cases, it may be that people had knowledge independently, or they would fail for some other reason. But why shouldn't the court say that the issue of whether the duties arose on the basis of the terms of business alone is something that's fit for determination between Bambatch, who are perfectly who want to fight it on that basis because they've got to, even to get to first base?
Well, there's a distinction between that suggestion, my lord, and perhaps what the judge has actually done. As I understand what the judge has done, given the invitation by my learned friend's side, is to direct that the question of bribery is determined only by reference to the terms of business. In other words, we wouldn't have our second punch. There would be a declaration that we've committed the tort of bribery at the end of the first trial. That in my respectful position, must, on any footing, must be inappropriate.
Right.
We can't be shut out from that. Your lordship's proposal is a slightly different one,
Yeah, okay, well, it may well be that's a fair point, but in a sense, the question of the existence of the duty or the existence of the duty of disinterested advice, if that's the necessary touchstone for both bribery and fiduciary duties, if that's right as a matter of law, as derived from the standard terms of business, is something that would be common to any claimant trying to establish a cause of action against you in this respect, because that's where you inevitably got to start.
But where we would say the judge would end up with it is, and this is obviously, we would be trying to persuade the judge that we're right about this, that there would be a trial on your lordship's proposal. So just a sort of prima facie trial based upon the terms of business.
Well, if you
which
win,
we would say, well,
if you win, there ain't going to be anybody going to stage 2 unless they have a completely bespoke set of representations from you, which is not going to be a concern for you because you can just fend them off. But if you are wrong, and it is established that there's a duty or the potential for a tort of bribery, then there may be individual questions then of how to deal with people's knowledge.
So what your lordship's proposing is that the court would only resolve whether our, as it were, generic defence to the claim based upon the terms of business is right or wrong. The court wouldn't then be making any determination about whether there was, in fact, a relevant disinterested advice duty, because it won't have considered the necessary circumstances to make that determination. All the court will have seen is there's an obligation to avoid conflicts in the terms of business.
Well, it's actually to not just to avoid conflicts of interest. The actual provision is that you. Sorry, I need to try and find it. That you have to practice competently, conscientiously, and objectively, putting the client's interests foremost, and avoiding a conflict of interest. So there's quite a bit more than just avoiding a conflict of interest.
Well, my submission then was using that just as a shorthand for the whole of that. But my point's the same, my lord, which is that
coupled with your implicit, it may be said implicit recommendation of CPA as a suitable person to deal with renewals.
Well, I'm not sure. I mean, your lordships have got my submission. That's an inappropriate salami slicing of liability. And in our submission, that's just wrong in principle. I have a separate point to make about whether that's sensible or appropriate as a matter of discretion, and I'll come to that as quickly as I can. Can I? So I've made our pleading point. Our pleading point, in our respectful submission, if it's well made, puts an end to this, because one can see that it's not possible for a claim of this kind to be pleaded on a common basis. That's ground one. Ground two is individualised assessment. I think I have made all of the submissions probably more than once in respect of that point. Ground three is the same interest point in the sense of conflict, and we make 3 points about that. The first is that we say that the class is defined by reference to a matter which is in dispute. This is the point raised by my Lord Justice Nugee this morning. We say that because the class is defined by reference to clients that contracted on the terms of business, that's necessarily something which goes to the question of duty, and therefore the definition presupposes something that would be in issue in the proceedings. I made my submissions about that this morning. I'm not going to add to those further. That's the first point. The second point is that the claim was initially, as your Lordship seen, pleaded by the claimant on the basis of an actual referral or introduction of by M&C of Bambach to CPA, and that's been removed by amendment. And we do say that that gives rise to a conflict of interest, in that there may be clients in whose interest it is to say that they were referred or introduced. I mean,
why is that in Lord Legate's terminology not a divergence of interest, but a conflict of interest?
Well, because subject to my Lord Justice Snowden's proposal as to an issue that could be determined on a common basis, if one was determining simply the question of liability across the class, then the other class members have no opportunity to make that point.
Yes.
You can only avoid that conflict by bifurcation. That's the second point. The third point is a point about the need for the claimant to elect between remedies, but I can see that point has been pushed down the road, so I'm not going to say any more about that today. That takes me to discretion, and I think back to my Lord Justice Snowden's proposal. We've set out various points, paragraphs 60 to 66 of our skeleton, which I'm not just going to take you back to now, but can I just try and draw how we see all of this together? So this is a claim being pursued by a commercially motivated representative on a funded basis, so using litigation funding, where the funder's motivation is clearly monetary. Neither the representative nor the funder is actually interested in a determination of liability alone. Its interest lies in securing money judgments for members of the class. Nor is this a case where there is any actual value to any particular member of the class of any kind of declaration as to liability, or sort of declaration as a partial liability declaration. As I said before, there's no question of seeking injunctive relief. There's no value inherent in the declaration. So the members of the class, we suggest, have an interest in this claim, if at all, if it results ultimately in money judgments. But what we say is clear, and would certainly be clear on my Lord's proposal, is that any question of an actual money judgment in favour of a particular person is a long way down the line, certainly well beyond the point at which the partial issue of liability would be determined on my Lord's proposal. And it's clear, we would suggest, that no one gets to money judgment without their individual participation. So the debate I've been having with my Lord Justice Snowden presupposes that at some future point, the relevant class members come forward. Now that is one of the things about which those in the industry complain that our procedures don't accommodate, because in the sense that the evidence, and Lord Legate refers to this, the take-up, the opt-in processes don't result in many people opting in. And that's presumably why claimants, like in Google itself, could only financially pursue it if quantum could be done on a collective basis. So what the court's looking at now is, should the court devote court resources now to dealing with any issues that it decides, contrary to our submissions, can be dealt with on a common basis, in circumstances where the court knows that actually that won't provide any actual benefit until further down the line if people do in fact opt in. And the evidence as it's before the court now is that there has been little interest expressed by the members of the class, and I won't take you to it now, but maybe I can give you the specific paragraph references to Mr. Kenrick's evidence and the response evidence from Mr. Rouse. What we've got is evidence that 3 clients have responded to Mr. Rouse's, I think the phrase is, book building. You've got Bam Batch Fire Angel and then another client, Discreet Heat, which is not part of the litigation. And Mr. Kenrick's evidence is that even after these proceedings have been started and the terms of business were amended and these proceedings were later started, has not given rise to any particular concern on the part of the clients. And of course, in this case, unlike in cases like Google, the clients are necessarily clients involved in the commercial world. And although then the amounts may be small in respect of particular clients, they are commercial clients that can take that are able to take a more sophisticated and involved decision as to whether to participate in proceedings like this. So there's no particular reason on the evidence, and Mr. Rouse, through his solicitor's signature, declined to answer questions about the extent of the book building exercise that Mr. Rouse undertook and the response to that. And then the next point is that in that context, the judge and this court have been given no plan by the claimant. Indeed, and by plan I mean a plan about how you actually take this litigation to a point where there are actually money judgments in favour of individuals who have participated. Contrary, as it happens, to quite a detailed proposal that was put before Mr. Justice Warby in the Google proceedings, with information about funding and a review committee comprising, I think, at least one retired High Court judge. Nothing is said by my learned friend side about the future.
No, and the judge has simply said it's all down the road.
It's all down the road. But in particular, the claimant has not committed to pursuing the individual stages of the litigation further down the road. So you will find nothing in the papers which says that the claimant itself is committed to assisting the individuals pursue the claims, or perhaps more importantly, no commitment on the behalf of any funder to fund those later stages. But what you are being asked to do is to consider the possibility of my Lord's proposal identifying a narrow partial issue of liability in circumstances where you have no idea whether the use of court resources necessary for that will actually produce any monetary justice if the cases succeed for the claimants further down the road.
And that's the difference, I think you say, between a representative action and a collective proceeding. Collective proceeding, the claimant can recover damages for all, and then
there's a process about
some scheme.
Yep.
Whereas here, you say, well, the representative may be able to determine on the narrow hypothesis liability, but there will then have to be individualised liability issues, defences of the type you might want to run, plus individual claims for damages in relatively small amounts building on that. And you say there's no connection between the one and the other.
Yeah. We've asked in correspondence whether we've effectively asked about commitment to the future and haven't had a satisfactory response. But it's fair to say that the claimant itself has indicated that the ban batch claim is a claim which is capable of being pursued on its own, even if the representative action is being dismissed.
It's for what, £6,000 or something?
But that doesn't, in our respectful submission, really answer the point about whether court resources should be used in a process of this kind.
Well, on the face of it, the ban batch claim is what, £6,000?
6,500,
which presumably has been eaten up today.
Well, and some, my lord, I'm sure.
Yeah. Well, yeah.
I mean, obviously, it's not commercially viable as a claim on its, and nobody's suggesting that it is. But our point is, the point I'm making now is a broader one, which is the court, in deciding whether to adopt the kind of proposal my lords suggested, the court shouldn't shut its eyes to the future and should be satisfied before doing so that it's a process that's got some prospect of actually producing, if the claims could succeed, monetary remedies on behalf of the class in due course. And there's simply no basis on the evidence for thinking that there would be sufficiently material opt-in to make that justifiable use of court resources, or indeed any information at all about how that individualised part of the proceedings would be funded and pursued. Thank you, my lord. I know I've considerably overrun, but...
Well, I don't think that's your fault in any sense, Mr. Mitchell. We're grateful for your submission. Anything else? Yeah. Thank you very much.
Thank you, my lord.
Yes, Mr. Leslie.
My lords, good afternoon. This appeal raises certain fundamental points about representative action procedure and its application to claims for secret commissions. As the court is aware, Mr. Justice Robert Knowles held that the procedure was available to the claimant in these proceedings. He held that the representative class shared the same interest in the proceedings within the meaning of 19.81, and he exercised his discretion to allow the proceedings to proceed. Now, we say this appeal turns on 4 core points. First, the law of secret commissions establishes that only 2 elements are required to impose liability on an agent: a duty to act on a disinterested or non-conflicted basis, and receipt of a payment notwithstanding that duty. Second, we say that the relevant duty in this case can be identified in the standard terms of business of MNC.
Just say that again.
We say that the relevant duty can be identified in the standard terms of business of MNC, Marks Clerk. If that contention is correct, then all that is required to establish liability against both MNC and LAR, the second appellant, is a payment. That will complete the cause of action and expose each of the appellants to the full panoply of remedies in equity and at common law. Third, there can be no doubt, we say, that the proposed class would be entitled to a declaration. In this respect, I respectfully pick up or reflect the comments of my Lord Justice Snowden, a declaration further to CPR 19.8 as to the meaning of the standard terms of business and the duties arising thereunder. Those terms of business are generic, uniform across the class, no question that their interpretation should be subject, we say, to individual circumstances. Now, in many cases, that might be...
So you say no question that their interpretation would not be subject
to individual circumstances. Of course, I'll return to that.
Sorry, you mean that individual circumstances don't make any difference to the interpretation?
Well, that's right. If one had a bespoke contract, one might seek to suggest that the factual matrix was relevant to the interpretation of that contract. These are standard terms of business.
Right, you put it in terms of interpretation, but do you accept that interpretation as such is not sufficient to get you to the existence of the duty? I mean, it's said against you. The duty arises out of the terms of business properly construed, but that's not the end of it.
Well, we don't accept that on the facts of this case, and of course I'll deal with that in some detail.
We'll come back to that. Fourth?
If I might just finish as it were the third point, because it's important. We say that as to the potential declaration as to the meaning of the terms of business, in many cases that might be the end of the representative part of the proceedings. But in this case, in the case of a secret commission, uniquely, once liability is established, then no proof of causation or loss is required. Entitlement to relief follows automatically. Fourth, the appellants say that the potential existence of individualised defences means that CPR 19.8 is not available. I discern that there may have been some evolution in the way that point is put against me during the course of my learned friend submissions. But we say in any event that that is an error. The question is whether a common issue arises that can be determined on a class basis. If it does, then individualised defences can be accommodated. Indeed, there are a number of examples of exactly that approach in the authorities. We say that the potential existence of individualised defences goes to discretion, not to jurisdiction. As a result, we say that a substantial proportion of the present appeal is misdirected. During the course of this response, I shall take the court through the grounds of appeal and seek to demonstrate that much of the appellant's argument misunderstands the simplicity and flexibility of CPR 19.8. Now, I had a speaking plan, but given the time, I wanted to deal with 10 responsive submissions addressing some of the matters addressed in my learned friend submissions and raised by my lords this morning.
In your 4, you don't deal separately with discretion, the points that Mr. Rachel mentioned in the last quarter hour, 20 minutes, but I assume you're going to deal with those at some point, either in your 4 core points or separately.
That's correct. The point taken against me is that one doesn't know what's coming down the road. Of course, we've in fact embarked on that road already, had a CMC, we have a second CMC lined up in January, but of course the specific points that are made against me on discretion, I shall come and get to those tomorrow.
Will you give us some help on Google? Because I don't really understand, and I hope this won't be taken amiss, and they won't think that I'm party pre to this, but Lord Legate doesn't seem to be clear as to whether he was talking about bifurcation in the context of discretion or substance, because he mentions it at paragraphs, I think, 58 and 81 in both parts of his judgment, as Mr. Mitchell pointed out. And I would like some help. I know you say it only comes in discretion, but I'd like to have an analysis of what Lord Legate was saying, because I find it quite difficult.
Yeah, that's understood, and it's a point that goes to the heart of the appeal. And we say one has to be very precise about the way that Lord Legate articulated the issues. There are 2 questions always before the court. I'll come back, of course, to CPR 19.8 in detail. There are 2 questions: same interest and discretion. And one has to be precise as to which common issue is said to give rise to a same interest, and whether that gives rise to questions of individualised assessment, which will go to the existence of a common issue. And then secondly, of course, the court then exercises a broader discretion. Now, as to that, the point as to the individualised assessment and same interest, I propose to deal with that as my second responsive submission that I'll make now. The reason I do that is because my first submission, as it were, sets it up. So the first responsive submission is this, that there is an elision at the heart of my learned friend's submissions. In submissions, he mentioned at various junctures that the claims are not common, or the question for the court is whether the claims are common. Now that's the wrong question. The definition of claim within CPR 19.8 has been authoritatively explained by Mr. Justice Andrew Smith, as he then was, in National Bank of Greece and Outhwaite. That's at paragraph 30. It's tab 5 of the authorities bundle, page 119. But in any event, it's the classic definition that the same interest in the claim means proceedings. So what it doesn't mean is that all of the claimants have to have the same cause of action, the same interest in an entire cause of action. The question is if there's a proceeding that gives rise to issues in respect of which class members have the same interest. CPR 19.8 is about resolving common issues. And that's what Lord Legate held. That's what I'll take the court in more detail, I suspect now tomorrow morning, to that core point. But what's important is that those issues need not touch each part of the claim, or even each part of the cause of action. And in fact, one point taken against me is the suggestion that liability cannot be bifurcated. It was one of that was a core submission. Now that is simply not correct, and one can see that firstly from the judgment of Lord Legate at paragraph 58, where he makes clear that it is not necessary to show damage, even where damage is a necessary ingredient of the cause of action, in order to constitute a representative action.
Yes.
And indeed, there's another even more vivid example of that in Prudential, which is the case cited at paragraph 58 by Lord Legate. In that case, what Mr. Justice Vinelaw did was he was considering a claim in the tort of conspiracy. Now, of course, there are 4 elements to completing the cause of action in conspiracy: unlawful means, combination, intention to injure, and damage. Mm. And what he did was he granted declarations in respect of the first 3 elements of the cause of action, leaving damage over for individualised claims in future. So it is simply not correct to say that liability cannot be bifurcated. It can be, and it has been. That takes me on to the second responsive point, which concerns individualised assessment. Now, we entirely agreed with the formulation of my Lord Justice Nugee this morning as to the relevance of individualised assessment to the determination of a common issue, the identification of a common issue in the same interest. But
can you tell us what that was, in case we've forgotten?
Yes, that is that when one is looking at the common issue, if the common issue requires at its heart individualised circumstances in order to determine it. So the classic example being a claim for damages. As Lord Legate says, individual claims for damages for loss to individual class members typically will not give rise to a common issue, because, of course, the question as to what loss was felt by each individual class member is individual. But, of course, he accepts from that a scenario where each individual class member suffers the same loss or commensurate loss, identical loss, for example, by reference to a fixed fee under a standard term contract. Now, in that case, each individual class member suffers an individual loss, but there is a common issue that can be decided. And that's why we say it's important to start at the right place. one has to start with a common issue and then determine whether that can be determined on a class basis. One does not start with individual circumstances and then seek to read back as to whether there are common issues. And it's important to keep those two strands apart, because we say that my learned friend submissions are infected by the first error I've identified in the first response of submission. He suggests that if individual circumstances arise in relation at any point of a cause of action, then the claim can't proceed. It's impossible to constitute a representative action. But that's not right, because common issues may nonetheless arise. And so Prudential was an example.
Well, he doesn't really say that, because he accepts that a limitation issue which throws the burden of proof onto the claimant can be dealt with separately.
Well, we respectfully say he was inconsistent in the way he treats this, because in fact the limitation defence in paragraph 44 of the appellant skeleton argument, it said that the possibility of an individualised assessment, individualised defence of limitation, by itself de facto means that the action is not suitable for a 19.8 representative procedure.
As a matter of jurisdiction.
As a matter of jurisdiction. So there was a substantial backtracking from that position in oral submissions. We say rightly so.
Mm-hmm.
The third response...
So is the difference between, if you remember, the Master of Rolls gave an example of referring you to that well-known tradesman, Lord Justice Nugee, earlier in the hearing, on a sort of ad hoc basis, one assumes, but simply by word of mouth or otherwise, without telling anybody that there was a secret commissional kickback going on. That sort of case is much more difficult to envisage being dealt with by a representative action, because there's no commonality of, or there's a very limited commonality of factual circumstances to when you might have encountered the master rolls in such mode. Whereas you say, I think, is this right, you have got a common basis because it's the D's and terms of business. So that any sort of, that is a firm commonality which you can focus on to identify an issue by reference to those terms of business. I mean, have I understood that's
correct. That's exactly correct. And indeed, it's that very point that takes me to my third response of submission, was that once a same interest in a common issue is identified, then the court's discretion to allow the action to proceed is engaged. Of course, that discretion was exercised in this instance.
Yeah, we're talking as a matter of jurisdiction here rather than discretion. There are other discretionary factors.
That's right. Yeah. It's the jurisdiction is engaged, and so that's why the potential existence of individualised defences is not a jurisdictional matter, because the common issue still exists. There's still a same interest in the proceedings in relation to that issue, so the jurisdiction is engaged. The question is it desirable or convenient to determine that common issue in a class basis, notwithstanding, for example, the possibility of certain individualised issues arising as against individual class members.
Don't you have to deal with the point that he makes, that the question of knowledge is central to the existence of the relevant duty in this case, notwithstanding the terms and conditions?
That's exactly what I will have to do.
And linked to that, the circumstances in which the terms and conditions were actually entered into in terms of both knowledge and placing reliance. I mean, they're linked points.
That's right. In fact, I shall deal with them to some extent at responsive submissions 5th and 7th.
Okay, we'll wait.
But I shall address that point head on in the morning. And take the court to both to the terms of business and to Wood, and say what we say Wood stood for. So we entirely agree. We have to grapple with that point, and we say we have an answer. But I wanted, given the hour, to give, as it were, an indication of where we're going with those points.
Keep going. You've got 10 minutes for 7 submissions.
As part of this third submission, we say that once the discretion is engaged and the case has been allowed to proceed, then everything that follows from that is effectively a matter of case management. And in that respect, we respectfully agree with my Lord Lord Justice Nugee that whether or not particular defences may arise, or the definition of a list, or what may be the proper definition of a list of issues or disclosure review document,
All for trial.
all of those are case management issues, and all of those are, and in turn the issues for determination are issues for trial. Those are issues for the trial judge. And in that respect, we note an interest, to us, a resonance with the observations of Lord Justice Mummery in the Emerald Supplies case, where at paragraphs 11 and 69, that's Authorities Bundle, tab 8, pages 164 and 175, he held that once the claim proceeds, really the machinery of 19.8 and how it works is a matter for, in his rather vivid formulation, the hurly-burly of the bear garden.
But you're not trying, you're still talking jurisdiction, are you, at the moment? You're not trying to sort of do a nifty little sidestep round the big discretion question that's put against you, that it's just all case management for the future, because what's said against you is, even if you're right on jurisdiction and it can be done and we can identify a particular common issue that can be determined leading to a declaration, where's it going to go? There's just no future to this litigation done if in fact there have to be a series of individualised steps, including, in fact, one would have thought individual proceedings to recover individual damages by individual claimants, which at the moment the defendants say, well, the court's got no sight as to whether any of that's ever going to be funded, or if so, how, or who's even interested in it. So that can't all just be put into a box and marked case management. The court needn't worry its pretty little head about it. That's not what you're suggesting.
That's entirely correct. We have to tackle that point, and we will. What we say is, of course, we face, as it were, I put the point respectfully, but a barrage of objections as to the way in which these matters might be case managed to trial. And we say that a large number of those criticisms or objections are really criticisms about the way about case management decisions that we say don't give rise to points of principle. They're matters ordinarily for the first instance judge. And that's what Lord Justice Mummery identified. So we would say, by way of illustration, the formulation of case management documents is something that is primarily for the judge and for the first instance judge. And so that I'm in this submission addressing those objections. I entirely understand my Lord Justice Snowden's concern that I tackle that bigger point at the end of my submissions. The fourth point is that we say the focus of this case is on the meaning of the terms of business, and the meaning of those terms is set out at issues 14 and 15 of the list of trial issues. That's supplementary bundle tab 45. Now we say that is the paradigm example of a representative action, and that is in fact identified by Lord Leggett at paragraph 52 of Lloyd and Google, citing the Irish Rowan, a case where multiple insurers had separate contracts in the same terms. And we say that having established the meaning of the terms of business, whether the duties that we identify arise, then the receipt of payment, notwithstanding those duties to act without conflict, notwithstanding those duties of disclosure, the receipt of payment engages the tort of bribery. And we suggest that where my learned friend suggested that may not be sufficient to engage the tort, we disagree, and we say we have an answer in would. And just responding to a point that was raised by my Lord Justice Snowden and Lord Justice Nugee, we do seek a determination of the existence of a no conflicts duty. There was some question as to whether there was a difference between the tort of bribery and a breach of fiduciary duty. And in that respect, we say that our approach reflects the observations of Lord Justice David Richards in Wood at paragraph 50, where he says the label attached to the duty is not significant. The question is what the content of the duty is. And at issues 14 and 15, we make clear that is the duty to act on an impartial basis without, in a disinterested way and without conflict, that is critical. And of course, that's putting it negatively as a positive articulation as a duty to disclose. The fifth responsive submission is one that comprises 5 words that I wrote over lunch, which was, the duty is the duty. And that has a resonance with my Lord the Master of the Rolls' observation that once the duty is established on the terms of business, we say that is the end of the exercise. And we say that on the other side of the pool, there has been no convincing explanation as to how that duty might somehow be displaced if it is established in the terms of the contract. We say instead there's a different question arises, which is if a payment was received notwithstanding the existence of that duty arising from the terms, was there disclosure and consent? And we say the authorities established that the burden of showing disclosure and the receipt of informed consent lies on the agent. And we say that there's nothing unusual in suggesting that one can discern a duty in the terms of the contract and look no further. There are many categories of, for example, fiduciary duty, trustee beneficiary, director and company. It might be said attorney and client, where it is axiomatic that the relationship without further investigation is fiduciary. So we say there's the spectre of Edzé and Conway does not arise in this case. We say we only need to look at the terms of business. The sixth responsive submission is that it's suggested that we must plead a complete cause of action. And of course, I've in a sense dealt with that already by the bifurcation of liability. Now, it's suggested that this is somehow a novelty that we have not been able to identify. For example, the specific circumstances in which each individual class member contracted, the dates on which they contracted were bound by the terms of business at this stage. But it's not right, and it's not novel. In the Duke of Bedford case, it was common ground that not only could not all of the members of the relevant class be identified, they might never be identified. That didn't prevent the representative procedure going ahead. So the suggestion that this is a novelty is misplaced, we say. This has been part of our procedural law for more than 100 years. The seventh responsive submission is the suggestion, which of course I shall develop, that some form of ambient knowledge on the part of clients might be sufficient to answer the claim that there's a duty, or the allegation there's a duty. And we say, we make 2 points. The first is the one I've already made. The only way to discharge the duty once it's established is disclosure and informed consent. The second point we say is that here, it's in fact a special case, because exactly as in Wood, we say that on the standard terms of business, one sees an express representation or assurance that there's no conflict, that no conflicting commission is paid. And we derive that from a couple of terms that, of course, I'll take the court to tomorrow. With the court's leave, I have 3 final 8th, 9th, and 10th very short submissions, if that's helpful.
I think we're going to have to stop there. What about timing for tomorrow? How long do you think you're going to be?
My lords, it's a substantial proportion of my submissions can be reduced in light of some of the exchanges this morning. Nonetheless, I would have expected that I will need to speak until 12:30 tomorrow morning.
Right, well, I suggest we start at 10:15, and then you can abbreviate that to 12:15, and that will give Mr. Mitchell a reasonable reply. And we'll do our best to give you a good run.
Very good.
Okay, Thank you very much indeed. 10:15 tomorrow.
All right.